Mr. Boyd has filed for divorce on and off during our marriage repetitively. I thought this was just a bump in our road. I only really knew about this the last 3 or 4 days, but I didn't know he was really going through with this.
Yes, she did, because she mentioned every day, we have 30 days, we have 20 days.
I can't figure out why anyone would willingly subject themselves to the perils and pitfalls of marriage, but people do, as it's still a very common institution. So is divorce. I have 2 hearings today. First is a fed-up fella divorcing this shrew. I worked the audio as much as I could, but there's no stopping her vocal fry. Then I have a case where Mrs. believes Mr. is hiding his VA disability benefits to avoid a child support money grab. Turns out Mr. has been paying about 500% too much. Let's roll, nerds.
All right, if you can start your video, please. We're on the record in the matter of Rodney Boyd versus Mary Boyd. This is file 25-149360. Are you Mary Boyd now that I can see you?
Yes, sir.
Okay, welcome. So I had, just a moment ago, I asked Mr. Boyd if he was here and ready to proceed. He let me know, however, that he expected you to be here. I wasn't expecting you to be here only because you are listed as it being in default. But are you also asking this court to go forward with the divorce judgment today?
No, sir.
And on what basis would you oppose the relief that Mr. Boyd is seeking in the divorce?
Sir, Mr. Boyd has filed for divorce on and off during our marriage repetitively. I did not know. I thought this was just a bump in our road. He and I have been living together. We spent Christmas, Thanksgiving, New Year's Eve. I love you, still sleeping in the marital bed. I had no idea. I thought this was going to be taken care of. We were going to go in and just stop it after the holidays. We had no conversation about this going to be continued. And because it has happened so many different times, he's filed paperwork. I just thought it was an argument where, he was taking the upper ground and, kind of letting me know, hey, we got to get it together or I'm going to finish this because it has happened so many times. I only really knew about this the last 3 or 4 days that he was not stopping it. I have not talked to counsel. I have not slept, sir. I have not eaten. I have no money. I have nothing. I don't know what I don't know, sir. I don't, but I didn't know he was really going through with this. I mean, we live in the same house.
Your Honor, yes, she did, because she mentioned every day, we have 30 days, we have 20 days. I tried to talk to her about this. I've tried, and she shut it down because she didn't want an argument. I've filed multiple times.
I'm the person to ask this question, Mr. Boyd. Is it your view that the marriage has been broken down and that you want to proceed forward to a judgment of divorce?
Yes, sir. I could give you bases of why.
No, I don't need any basis. And the reason I don't need any basis is because Michigan is a no-fault divorce state. And that means bases are not allowed, and I don't need to consider them. I just need to make sure and make a finding that there's been a breakdown. Ms.
Yes.
Boyd, this brings up a unique circumstance for you, however, because while you have said things that have been directly opposed by Mr. Boyd, what it sounds like you're also saying, when you use the words like you haven't talked to an attorney, you also said you don't have any money. It leads me to believe you may be seeking to have any default that's been issued set aside. Is that what you're asking me to do, is to set aside a default?
I'm not sure what that actually means, but I would like to seek counsel if I have the option.
Ms. Boyd, let me explain it. I'm talking over you on purpose because there's a easy way to resolve the hearing today, at least in my mind. So I'm going to tell you what it is, and then you too will have an option to respond, and I'll decide how to proceed. You are in default, and what default means, Ms. Boyd, is you were served with process. That process service happened to you on October 17th of 2025. When you're served with process, you're served with a copy of what's called a summons and complaint. The summons is the notice that says you're being sued, and that summons also says you have this many days that you can respond, and if you don't, you can be held in default. Default under Michigan law gives the court several different chances. One of the things the court can do if you're in default is not allow you to be heard. That's something that's within my discretion. I'm not saying that that's necessarily what I'll do today. If you seek to have that default set aside, and to be clear, the default is in existence, Mr. Boyd asked for it. It was entered by the clerk almost 2 months ago on November 21st. He requested it on November 19th. It was entered in the court records on November 21st. So if a default stands, that means you don't have a right to be heard. If I make the finding from Mr. Boyd's testimony that there's been a breakdown of the marriage relationship. On the other hand, if you wish to ask me to set aside a default, there's a legal mechanism for you to do that. And there's a motion to set aside a default or a default judgment. And the court rule is MCR 2.625. That court rule defines the things that you need to do if you wish to set aside a default. The first thing is you have to show good cause. Good cause is a valid reason or a good reason that I should set aside the default that's in place. The second thing is you have to file what's called an affidavit of meritorious defense. That means you have to tell me in affidavit form how you would defend against the claim. And that is, if Mr. Boyd, for example, was seeking to keep his truck and you thought the truck was marital property, you should have good cause perhaps could be that you have a defense as to why that should not happen. Those things are mandatory under Michigan law, meaning if you don't provide either one of those or both of those, then the court has a duty to maintain the default, in which case I have to decide how to exercise my discretion to allow you to proceed or to not allow you to proceed. Then I'd have a hearing where Mr. Boyd would be asked again whether or not he wanted the divorce to go forward and whether or not he could convince me that there's been a breakdown of the marriage. But again, a breakdown is a one-sided determination, meaning the parties don't have to agree on a divorce. One party has to make the assertion and convince the court of that. So even if you tell me later that you don't want a divorce, if one party, Mr. Boyd, tells me that he does, and I'm convinced of it, then I'm authorized to issue a judgment of divorce. So if what you're telling me, Ms. Boyd, is that you want a short amount of time to be able to research and decide whether or not you either want to defend or want to seek to set aside the default, I think it's reasonable under these circumstances to give you that time. But in fairness to Mr. Boyd, he's also told me he's ready to be divorced. He's taken the actions to get to this point. So I'm not going to provide a lot of different time. And if you don't file the appropriate paperwork under the court rule, you won't be able to have the default set aside. So do you have any questions regarding that process or what I've said?
What I don't understand. How many days would I have to be able to file that, or is that something I have to give you today?
No, Ms. Boyd, I'm trying to control these proceedings because I have several other matters to conduct today. You don't have to give it to me today. I would give you a reasonable time. If you're telling me you want time, I first have to know that. If you say you want time, then I'm going to consider a reasonable time, in part by asking Mr. Boyd what he thinks is reasonable, and then by making my own determination. So do you want time to try to set aside the default and or defend the case?
Yes, sir. Yes, sir.
Mr. Boyd, I can recognize by your body language you would prefer to go forward today. I understand that. But as I've already indicated, given the circumstances that are present, the disputed claims, I think giving some time to flesh out the issues is a better use of judicial time. So I know you're not probably happy with that. What do you think is a reasonable amount of time that the court should give Ms. Boyd to file the paperwork that she would need to set aside the default?
5 days, or I guess.
I don't.
Ms. Boyd, how long reasonably do you think you need to put together the paperwork to move the court to set aside the default?
Well, Your Honor, I don't have a vehicle. Mr. Boyd has our only vehicle, so I'm kind of at the mercy of anybody that I know to be able to get a ride. I would say I could have it at most in 2 weeks. That way I have time to find adequate to talk and to get everything that I would need to be able to put in there out to you and feel comfortable that I did my job adequately. And I still need to ask for rides to be able to do that, because I don't get very good cell service out here. So I can't even make phone calls out here. I gotta walk in the yard, and I got really bad arthritis. And if I slip and fall, it just puts me way back. So then that hinders moving and all that stuff. So I'm trying not to make it any longer either. But I am at the mercy of other people because I don't have a vehicle.
Court rules that it is appropriate to give you time to file the motion to set aside the default. If you file your motion to set aside within the next 21 days, I'm going to consider it timely. I'm also on my own motion going to set this hearing, the pro-con hearing, which is Mr. Boyd's request to have the divorce judgment entered in about 30 days. You're each going to get a separate notice. That's going to be at my next available date. That's at my standard motion day, which is about a month from now. If you file that motion timely, that is within the next 21 days, Ms. Boyd, and have it conforming to court rule, then I'll rule upon the motion on its merits. Mr. Boyd, if you wish to file a written response to that motion, you're entitled to. Just make sure and get it filed at least a day before the hearing so I have time to review it in advance of the hearing. At that next hearing, then in about a month, I'm going to do one of two or more things. One, if the motion's filed, I'll address it on its merits. If it's filed timely, Ms. Boyd. Number two, if it's not filed timely, I'm going to hear testimony from Mr. Boyd and determine on whether or not there's been a breakdown in the marriage relationship. And if he convinces me that there has been, I'm ultimately going to make findings and enter a judgment of divorce. At that hearing, I'll then determine and exercise my discretion, Ms. Boyd, whether or not to allow you to participate. Again, the law does not require me to allow you to participate if you're in default. I've not yet decided in total if I'll let you be heard or not. But I can tell you that if you have not properly moved to set aside the default, I have as an option to not allow you to be heard. I'm not telling you that's how I've decided to proceed, but if you want to be heard, you know how you need to do it. Do you have any questions, Ms. Boyd, before we break?
So it's 21 days. I have to make sure I have my paperwork into you so that way you can decide whether or not I can be participating in the next part of this
21
so that
days
I'm not in default.
that you
Okay.
you are in default and you remain in default until you file a proper motion to set aside the default under the legal standard that I've articulated and any other standards that are existing under Michigan law. Meaning I can't give you legal advice. I'm trying to give you the piecemeal portions of what you have to do. If you don't know what to do, or if you're not sure, you should seek legal counsel because there are requirements to set aside a default. Then if you file the motion timely, I'll address it on the merits and rule on it. Again, Mr. Boyd, if you want to file a response, you can in writing as long as you do so in advance of the hearing. Mr. Boyd, do you have any questions?
No, I fully understand, Your Honor.
I appreciate each of your patience. I know that on the one side, you want to be done with this case today, and on the other side, you don't want it to be existing. This is my view of the best way to proceed in light of both of those things. We'll see you next month. I'll have my staff send out that notice for the next hearing.
Your Honor, Your Honor.
I was quick question. More time today.
No, my question is just about the 21 days. Are those calendar days or business days?
The calendar days in the sense that it's 21 days from today.
Okay, thank you, sir.
This is a motion to modify child support. This was filed May 16th of 2025. The parties are all present on Zoom today. Mr. Perry, if you can please unmute and state your full name for the record, please.
Good morning, Your Honor. Michael W. Perry, Jr.
Okay, thank you. And Ms. Perry, can you please state your full name for the record?
LaShania Perry.
Okay, thank you. And can you both please raise your right hand to be sworn in? But do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth, sir?
I don't swear, but I confirm, yes.
Okay. Thank you. You are under oath and required to tell the truth, both of you. Mr. Dehemasian, can you state your full name for the record, please?
Garabet Degramasian.
Okay. Is everyone ready to proceed today? Ms. Perry?
Yes.
Okay, Mr. Perry, if you can please unmute and stay participating in this case, I'd appreciate it. Are you ready to proceed today?
Yes, I am.
Okay. And Mr. Dehemasian, you're ready to proceed?
Yes, Judge.
And Mr. Dehemasian, are there any agreements in this matter?
No, Judge.
Okay. And you may proceed. And everyone, this is your chance to present evidence, testimony, witnesses to me about your position. You may proceed, Mr. Dehemasian.
Thank you, Judge. Judge, I ask that the court take judicial notice of the modification filed by the Office of the Attorney General on May 16, 2025.
Okay, I take judicial notice of your pleading.
And in that pleading, where I ask that you take judicial notice that we're modifying a prior order that was signed November 29 of 2017.
See that your pleading references an order from November 29th of 2017.
Thank you, Judge. And Judge, I called Mr. Perry first. Mr. Perry, can you state your name for the record, sir?
Yes, how you doing? Michael W. Perry, Jr.
Mr. Perry, now it's been more than 3 years from the prior order, right? The prior order was signed on or about sometime in 2017. Isn't that correct?
26, I believe.
Okay. And in that prior order, you were ordered to pay $839 a month. Isn't that right?
I don't have it in front of me, but I believe it was more than that.
Okay. Now, Mr. Perry, are you currently working?
No, I'm retired.
And where did you retire from, sir?
Post office
Okay. And when did you retire?
in June of this year.
And how much do you get paid in retirement?
I get paid $889 a month.
Okay. Now, you've submitted paperwork to show that you make that $889 a month. Isn't that right?
That's correct.
Okay. Judge, at this time, I offer Exhibit 2. It's out of sequence, which shows a summary of what Mr. Perry submitted to the court.
Okay, does anyone have any legal objection to me admitting Exhibit 2 into evidence?
No, I don't, Your Honor.
Okay, Ms. Perry, do you have any legal objection to me admitting Exhibit 2 into evidence?
No.
Okay, Exhibit 2 is admitted.
Now, Mr. Perry, the document that you provided has $889 that was paid to you in August, $889 that was paid in September. So are you saying that you're making basically $889 a month from your retirement?
Yes.
Okay. Do you have any other source of income, sir?
My wife's?
Do you have any source of income from you
No,
besides this 889?
no, not for me.
Okay. So is your testimony here today that you make $10,668 a year?
I'm not sure. I retired in June, so this is my first. I've been retired 5 months.
Okay.
So of course this year I'm going to clear that amount because I work from January up until June. Now going into next year, if that's what the numbers come up to, that's what I make. But I have no debt.
Okay. Now, have you ever been eligible for VA benefits, sir?
No.
Okay. Would it surprise you if there's a document that says that you had VA benefits?
It would surprise me because from my understanding, from 2014, 2015, I've been divorced for 9 years. I'm remarried. So if that document was available and was there, it should have been presented 11 years ago as of the date. So for all I know, it's a fake because I have not released any documentation from anywhere.
Judge, I offer it as a Exhibit 1, VA documents.
Does anyone have any legal objection to me admitting Exhibit 1?
I do.
What is your legal, okay, thank you, ma'am. What is your legal objection, sir?
Basically, I've been divorced for 9 years. There's no way to have access to any of my VA records or files where we're not husband and wife no more and haven't been in 9 years.
So what is your legal objection?
Forgery. I don't believe it's true. It's not for me.
Mr. Dehamajan, have you proved up that this is admissible?
Judge, it's a document provided by a party, Miss Perry, and
okay, does that meet the rules of evidence?
It's a government document which shows that it's.
Did you get this from the government?
No, I got this from Miss Perry.
I don't believe you've proved up.
I can prove this document through Miss Perry, Judge, if I can continue with other line of question.
You may do so.
Thank you. Now, Mr. Perry, do you have private health and dental for the children?
I do.
And are they on, what type of private health are the children on right now?
GEHA, medical and dental. And I have another policy through MetLife for the dental, which is a higher coverage.
Okay. Now, the first policy you're talking about, is that some type of postal office retirement type plan for your children?
Correct.
And in the second?
Can you explain that again, Mr. Dehamajan?
Yes. Can you repeat the first plan that you have the kids on, sir?
The first plan I have them on is by the same company. It's GEHA. I have a medical plan and I have a dental plan through them. But I also have an additional dental plan through MedLife that offers more coverage in case of more severe things because my plan through my retirement doesn't cover very many things. So I have an additional plan in case they need more care than provided by my government plan.
Okay.
Mr.
And-
Keating plan just medical, or is it medical and dental, or is it just medical and very little dental?
It's medical, dental, and vision.
Okay. Mr. Division, how many children are left before the court?
I'm sorry.
Can we establish that through testimony?
Yes.
Thank you.
Mr. Perry, there's 2 children in this case, right?
In this case, there's 2. Outside this case, I have another son biological, and I have 2 by marriage. So there's 3 other, and my wife, of course.
When you say by marriage, are you the biological father of those children, or did she have those children and you married into it?
I married into the 2 girls. I have another son outside.
And how old is your son, sir?
8.
And does your son live in your household?
No.
Are you on child support for your son?
No.
And there's, to be clear, there are 2 kids in this case, Maya and Jordan.
Correct.
And respectively, one's 10 years old and one's 17 years old.
Correct.
Judge, pass the witness for at this time.
Okay. Ms. Perry, do you have any questions for Mr. Perry?
Do I have any questions for Mr. Perry?
Yes, ma'am. You are a party to this case and entitled to ask him questions if you would like.
Am I able to come back and ask questions at another time or?
Possibly. Yeah, you will actually, because you can call witnesses. So yes, ma'am.
Okay, I'll come back and ask.
Mr. J. you may call your next witness.
Judge, I will do that. I have a couple more questions for Mr. Perry. I just thought of it. Mr. Perry, now you said you're married right now and there's 2 kids in your household, right?
Yes.
Are both children not biological?
Correct. They're both by marriage.
By marriage. Okay. I just wanted to be clear. Okay. State calls Ms. Perry. Ms. Perry, can you state your name for the record?
LaShanya Perry.
Okay. Now, Ms. Perry, now you've submitted a document from the VA. Isn't that right?
That's correct.
Okay. When did you obtain this document?
While we were married. The documents are from our divorce proceedings.
Okay. Did you obtain this VA document directly from the government?
No, they were in our household. They were a part of our divorce. When we put the packet, my lawyer and I put the information together because she asked me for documents. Mm-hmm. What did I have to prove his income? These 2 documents were a part of that. So I pulled it from my divorce decree paperwork.
I'm just trying to figure out where you got the documents. Were they provided by Mr. Perry?
They were we had paperwork that we had together in a lockbox that we would keep in a lockbox. All of our medical birth certificates, any important information that was there. That paperwork was there because I needed it. We have done different things on our home, as far as we had to have that letter to prove that we could get discounts for I forgot what it is. You send them that letter and then they can give you a discount on your taxes on your home. So it was readily available to me because I was the wife.
Let me ask you this. How did you receive the paperwork? Through email, through mail? How did you come by this paperwork?
Like I said, we had all of our important documents that were in a lockbox that we kept together as husband and wife. It was in a box.
Who put the paper in the lockbox?
My husband. It was our birth certificates. It had our marriage license in there. It had any important documents for our house, anything that was in there that we needed access to, his checkbooks, his accounts, all that information, his paycheck stubs.
Let me ask you this. who had access to this lockbox?
He had access and I had access to it. We both had access to the lockbox.
So is it safe to say if you didn't put this document in the lockbox, it would be him?
Yes. It's his, yeah. It was his paperwork. We just kept it together. So in case like if we had a fire or we needed to leave really quickly, we had all of the documentation, all the paperwork that we needed. So he would just pick that box up and then we could go.
Yeah, it held your most important papers that you could grab and go in a moment's notice, right?
That's correct.
And then you're the one who provided this document, and you want to use this as an exhibit here today?
Yes, because it was a part of our divorce decree paperwork. Also, it was in that court system too.
Okay.
Was that?
Good.
Were VA benefits considered in their divorce when child support was set in their divorce?
No, it was not, because at the time they did not, it was something on the lines of they didn't use VA benefits for your income. So the paperwork was given to my lawyer and provided, but they did not count it from what I understood. But I mean, because I was married to him, I have access to that paperwork. He has access to paperwork, my paperwork, our house paperwork, all of those forms.
And this document, you have personal knowledge of this document, right?
I sure do, yes. I mean, he showed me numerous award letters when we were married. I knew he was applying for benefits. He has disclosed to me as maybe probably not even, I would say probably like a year ago, that he was going to be getting the children ID cards because he's 100% disabled. And we have cars in our yard that have disabled veterans tags on them. And from what I understand, you have to be named as being disabled to be able to get those tags. And our two sons have it, and he has it on his Porsche, and he also has it on his Corvette, disabled veterans tags.
Okay. Judge, I offer this document as Exhibit 1.
Mr. Perry, do you have any legal objection?
I do.
What is your legal objection?
Again, forgery. This document is from, it says 2014, 2015. It's from 10 to 11 years ago. If it was relevant, and if it was legal, and if it was real, it would have been addressed at the time of a divorce in 2016.
Well, right now, I believe you're trying to backwards use this for impeachment, because the issue is whether or not you get VA benefits. I don't even know if you were in the military of any kind.
I'm not sure.
I don't know if you're a veteran or not.
I'm not
what
sure.
you received, sir, but I know that you're paying a lot here on $889 a month.
What I'm saying is she's trying to submit a document from 11 years ago that wasn't given to her by me. The lockback she's speaking of, when I was put out the house in February of 2016, I took the lockbox. So there's no way she had access to anything in there because I had it with me with all the documents inside. I managed everything, not her.
I'm going to find this goes to weight versus admissibility and admit the letter. You're free to continue to explain to me why you believe it's fake. It also would only be relevant to this if he's receiving anything now. There's a lot of questions here, but I'm admitting states Exhibit 1.
Now, Ms. Perry.
Yes.
On the first page, where the VA language starts, do you have it in your possession, ma'am?
Yes, I'm reading it.
Okay. Now, under VA benefits information, it says that at the time, which is January 1, 2014, it looks like he was 50% disabled or 50% covered, and he was receiving an award of $1077.15
Yes,
per month. Isn't that right?
that's correct.
Mm-hmm. And then if you go to the next page, it looks like under the VA benefits information, towards the end of that same year,
Yes.
he was bumped up to 60%, and the date they're using is December 1, 2014, and now the award is 1323.09 per month. Isn't that right?
Yes.
Okay. Now you don't have anything current, correct?
No, because I don't have access to that information because I'm no longer the wife. When we were husband and wife, I was able to have the access. He was forthcoming with it. He was sharing it with me. But now that I'm out on the outside, the only thing that he has been sharing with me is that he is now 100% disabled. And my son goes to school off of his college benefits. Our oldest son, he's receiving college assistance because of him being disabled.
Okay. So you're not able to get current VA benefit documents, right?
No, that's why I'm asking the court to help me because I don't have access to that information.
Lest you get frustrated with the court, I'm just going to let you know I am not allowed to do any discovery or research or investigation on behalf of any of the parties. That's just not the role of the court or judges. We're here to listen to evidence. Mr. Jehemajan, did you all do any subpoenas?
We didn't do subpoena, Judge. We just did regular discovery. In light of this information, Judge, we could...
You said you were ready to proceed today, Mr. Jehemajan.
Maybe we can do temporary orders, Judge, and then come back on a final trial.
I will decide based on the testimony I hear.
Okay. Now, Ms. Perry,
Yes.
you believe that he's still getting VA benefits, right?
Yes, because we still have disabled veteran tags on the children's cars. My child is actually going to school off of the VA assistance. Yes. He has disabled veteran tags on his car currently right now as I pick up my son every visitation with him. So yes.
Now, based on these facts, you want him to produce these a current version of the VA document, right?
Yes.
You believe that he's not being truthful and forthcoming with getting VA benefits. Isn't that correct?
Unfortunately, he's not. He's not being truthful about it at all. I mean, there's proof all around us. He has disclosed it to our children. Each one of them know. I don't know why now he doesn't want to be forthcoming, but he's not telling the truth.
Okay. And are you asking this court that for temporary orders so he'd be able to produce what his actual income is?
Yes, please.
Okay. Pass the witness, Judge.
Mr. Perry, do you have any questions for Ms. Perry? And please unmute if you do.
No, this time, Your Honor, I don't have any questions. I think everything is pretty much self-explanatory. It's a witch hunt.
Okay. Mr. Jehemajan, do you have any other witnesses?
No, Judge.
Ms. Perry, do you have any witnesses you'd like to call?
No, I wasn't aware that I could have any. I'm sorry.
Mr. Perry, do you have any witnesses you'd like to call?
No, Your Honor.
Okay. Mr. Jehemajan, would you like to make a brief closing argument regarding what you're requesting of the court?
Yes, Judge. Judge, in light of the testimony today, the state is asking that we have temporary orders, and then we come back for final, give a chance for Mr. Perry to give current versions of the VA benefits or some type of document that says he's not getting it.
Mr. Perry, does any of that exist?
No, Your Honor. And actually, I'm quite appalled that my time has been wasted today. He said he was ready to proceed. Yet he has something to proceed on. He's asking to be granted more time for me to produce something that is not relevant, nor does it exist.
Well, sir, if it does exist, it would be relevant. If you're getting VA benefits, it would be relevant. Were you in, I believe it was the Navy, were you in the Navy?
Yes, I was in the Navy.
Okay, so were you honorably discharged?
Yes, I was honorably discharged.
Okay, so you're not in the Navy anymore?
No, I'm not.
Okay. Is there some reason you don't get any benefits after being in the Navy?
You have to be
Discharged?
you have to be medically approved to get benefits, and sometimes even when you are medically approved, it can be taken from you. At that time, I did have somewhat, but it was pending medical examinations.
And so do you have on your car tags?
Well, yes, from that period of time, yes.
So you're using tags from 2014.
What I'm saying is, you can be a disabled veteran without getting compensation for being disabled if they take it back. It's something called, basically, it's a rating system. And 10 plus 10 don't equal 20. It's not like school mathematics. It's a weird system to have.
Am I able to say something?
What would you like to say, ma'am?
Based off of what I understand how VA benefits are, you have to go to an actual doctor and get a doctor to sign off saying that you are disabled. So a doctor justifies that, and then you apply for the VA benefits. Everything is still currently moving within the VA benefits because of my son being able to get funds. You can't get funds to go to school unless he is a disabled veteran, as well as you can't have the tags on your car. All of the tags are current. And I'm only asking for these benefits. I'm asking for this for my children so they can have the support that they need, because the economy has changed so drastically. I need those funds. My daughter is a senior in high school. She's going to graduate. She's going to need assistance. And I need that assistance to provide for them.
So basically, Your Honor, what she's saying is she doesn't want to go to work and work for him. She's trying to go on a witch hunt. And
I don't believe she said that, and that was a little rude. So please, let's not throw mud at each other.
The reason why I'm saying that is,
like, everybody here are hard workers and are, actively involved people. So
the reason why I'm saying that, Your Honor, and again, forgive me, but there is no school that my son is going to on my behalf for no benefit. The house that she's living in is in my name, so she's staying in my rental property. So the cars that she's talking about, that they are, I bought and paid for while I was working. I've done nothing but assist my children. There should be a police report on file that they had to get involved for me to even to see my
I
children.
didn't file anything with the court, and as I explained earlier, I cannot investigate on behalf of either of you. So if you all want to produce evidence to me of all these things you're talking about, you're all free to do so, but I can't go hunt for titles and
That's not that information is not true. We've had several family violence incidents that have happened, so that information is not true, Your Honor. And I'm here for my children. That is all that I am here for. I just want my kids to be taken care of.
This has to be done orderly. So, Mr. Damian, I didn't really hear any request from you except for a temporary order, but I don't know what you're asking for in the temporary order. And then I'm a little concerned that he's going to say he doesn't have the documents. So unless you're doing anything yourself to get them, I'm not sure that we're going to be, I don't want to waste any more time.
Yes, Judge.
If you can tell me what you're asking for and what your plan is, I would appreciate it.
Yes, Judge. Judge, we're requesting that that we have temporary orders today, and it could be set at what he's making, what he alleges that he's making, $889 a month in retirement. That the health and dental be covered through Mr. Perry, through another source, through his retirement, and that additional coverage that he bought. Yes, Judge. The last thing I was going to say was we request that this be temporary orders, and that would give us, the Office of the Attorney General, a chance to subpoena the VA benefits. In light of the evidence today, there is some question as to he may be receiving VA benefits currently.
But I wouldn't be bringing this information forward if I didn't need the assistance for my children. If I would have known that I could have had witnesses, I could have brought my children could have testified themselves. I didn't know that. That's my ignorance of the court. I just didn't know.
I'm going to render, I'm going to grant a temporary order in this case. At this time, I'm setting the child support based on the $889 per month. I am going to give him credit for that other child, the 8-year-old. So if you can recalculate that.
121 a month.
121. So I'm ordering that you pay, Mr. Perry, pay to Miss Perry $121 per month in child support beginning December 1st of 2025. There'll be a step down when there's just one child before the court, but you'll be back here before that happens, most likely. It's the plan. At this point, for now, I'm denying the non-disclosure request since she lives in his house and I don't think she's moving in the next month or 2 or 3. But that can be relooked at when you all come back to court.